Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. We come to you this MLK Day, Monday, January 19th, on the heels of a loaded week. The Supreme Court heard 4 cases, delivered 4 opinions, and accepted 4 new cases. I'm jazzed up about today's episode. We'll touch on all these things and more. Please follow, rate, subscribe, share, and review this podcast. You can find us on Apple, Spotify, YouTube, and wherever you podcast. Follow us on LinkedIn to get rundowns. Just search the High Court Report. If you have any questions, comments about the Supreme Court or any cases, reach out via LinkedIn or via email, scotus.cases.pod@gmail.com. I wanted to give a special shout out to you, my audience. Thanks to my original listeners who've been with me since the start, way back in April. And thanks to all of my new listeners. It's a real honor that so many people want to hear about my Supreme Court commentary. Thanks to everyone for supporting the High Court Report. All right, enough of the lovey-dovey. Here's today's rundown. First, I'll talk recent Supreme Court actions. The Supreme Court agreed to hear 4 new cases. Then I'll give a few comments on the 4 cases the Supreme Court decided at the end of last week. Finally, I'll give you my final thoughts on this week's upcoming Supreme Court cases. Stay tuned because we have a lot in store for you. We have an action-packed episode. I'm also going to nerd out a little bit. I'm excited. Let's get going. All right, first up, the Supreme Court agreed to hear 4 new cases. These cases involve the constitutionality of geofence warrants. There's also a patent infringement case, a case about Monsanto's failure to warn about the dangers of Roundup, and a case about the standard to plead cases involving underperformance of an investment fund. We'll get into the details later. I promise you we will preview that episode in detail once oral arguments are on the horizon. Now, accepting those 4 cases, that puts us at roughly 57 unique cases. Last year, the Supreme Court heard about 62 or 63 unique cases. So perhaps the Supreme Court will agree to hear a couple more cases, but that's basically it for this year. Again, I'll break down these cases as the dates approach, so stay tuned. Next up, the Supreme Court plans to release opinions on January 20th. I'll break down those opinions on Friday, January 23rd, maybe Thursday, depending on the number of opinions, but definitely by Friday. While we're on the subject of opinions, let's talk about last week's opinions. Having chewed on these opinions now for a few days, I have additional thoughts. I'll share those in a moment. Let's look at some of the numbers and the through lines from these opinions. At the end of last term, I broke down a whole host of end-of-term stats. One set of stats centered on the reversal rate, the rate that the Supreme Court reversed or vacated decisions. Last year, the Supreme Court reversed or vacated approximately 69% of the cases that they decided, meaning the Supreme Court reversed basically 7 out of 10 cases. It upheld or affirmed about 25% of the cases it heard. So what does that tell us? This shows that the Supreme Court views itself as more of an error correction service. They're not taking cases that they want to uphold or affirm. They're taking cases because they find an error and they want to reverse it. That pattern largely held up with the first 4 cases of this term. The Supreme Court reversed or vacated 3 of the 4 decisions and upheld or affirmed 1 of them. The 1 case they upheld arose from the Montana Supreme Court. 3 cases they overturned came from the federal courts of appeals. 3 of the cases they decided involved criminal law. 1 case involved standing and election. The 3 out of 4 overturn rate tells me that they're continuing this trend of serving primarily. These stats provide crucial details on how the Supreme Court will decide these cases. 3 out of every 4 cases they hear, they're going to overturn. That's a really important number. The Supreme Court decided 2 cases 9-0. Barrett versus United States and Case versus Montana. Check out my episodes from this past Friday to learn about these opinions. A different justice wrote each majority opinion. Justice Roberts, along with Justices Sotomayor, Kagan, and Jackson, penned the majority opinions. Justice Gorsuch wrote 2 concurring opinions and 1 dissenting opinion, followed by Justice Jackson, who wrote 1 majority opinion and 1 dissenting opinion. Now, judicial fracturing emerged early this term. In my episodes from June and July 2025, I talked about how fractured reasoning proves a feature, not a bug, of this court's composition. It's common to see all justices, or most justices, agree on the outcome, but for starkly different reasons. We see this fracturing play out in oral arguments, and we saw this fracturing rear its head in these opinions. Most notably, Bost versus Illinois, where Justice Barrett and Justice Kagan joined the majority's conclusion, but not the reasoning. Justice Barrett called the majority's rationale, quote, a bespoke standing rule for candidates. Expect greater fracturing this term, especially in the major cases. Second, I want to tune you all into a legislative history doctrinal debate that's percolating. Many Supreme Court cases involve the interpretation of ambiguous or unclear statutes that Congress wrote. Courts employ a variety of tools to interpret statutes. And these days, those tools mainly include text, history, tradition, context, and various statutory interpretation devices. Now, for a long time, courts consider legislative history as a tool to interpret statutes. With the rise of textualism, that method of interpretation became disfavored. Legislative history means looking at the legislative records created for the particular law at issue to see if these materials can shed light on the statutes. Legislative records include committee reports, hearing transcripts, floor debate records, and more. Statements from the representatives, the senators, you name it. Lawyers and judges sometimes consult this record to clarify ambiguous statutory text and to infer congressional purposes. Textualists reject legislative history because they see it as unreliable, manipulatable, and in tension with core rule of law and constitutional commitments. They argue that the enacted statutory text is the law and that going behind it to committee reports, floor speeches, and similar materials invites judges to smuggle in their own policy views. Textualists believe that Congress speaks through duly enacted statutory language that passed both houses and has been signed into law, not through ancillary documents produced along the way. Justice Scalia is famous for this. He framed legislative history as illegitimate because it gives binding effect to materials that never went through the constitutionally prescribed process of bicameralism and presentment. Textualists also attack legislative history as unreliable. They stress that committee reports and floor statements often reflect staff work or the views of a few members, not the understanding of the median legislator who voted. The median legislator who voted may have voted for the law for completely different reasons than their colleagues. Maybe the legislation passed as part of an omnibus bill, or maybe there was one part of a bill that the legislator really wanted to vote for, and the only way they could vote for that bill was to pass this other law. So textualists believe it's improper to prescribe a legislative history based on these documents when every single legislator had their own individual motivations for voting for a bill. They believe legislative history can be incomplete, drafted after the fact. Will this term mark the revival of legislative history? In a few cases, we've heard this term. Lawyers out of their way to revive legislative history as a tool to interpret statutes. And I'm thinking in particular about Cox v. Sony and FS Credit v. Saba. Paul Clement argued in both of those cases that legislative history supports his client's viewpoint. In oral arguments throughout this term, including in these cases and in the Trump tariff cases, Justice Jackson questioned the parties on legislative history. Now, fast forward to Barrett v. United States. It's a 9-0 decision. Justice Jackson wrote it. She garnered 8 votes for all portions except 4C. For Part 4C, it's only 3 paragraphs long. But why did she not secure the votes of every justice on this 3-paragraph section? She only secured the votes of Chief Justice Roberts and Justices Sotomayor and Kagan. So it's actually not a part of the majority's opinion because only 4 justices voted for it. What did the section say that caused the avowed textualists, Justices Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, to peel away? Legislative history. Justice Jackson argued that legislative history fortified the court's statutory interpretation in the United States. Specifically, she emphasized the total absence of congressional deliberation regarding cumulative punishments, which was a major issue. For example, she cited a 1994 Congressional Research Service report and other materials, including floor remarks from Senator Biden. Justice Jackson marshaled these materials to demonstrate why legislative history points in favor of this conclusion. The textualists withdrew completely from this section. Notably, however, Chief Justice Roberts, who's another textualist, joined this portion of the opinion. Why? It's doubtful he would have authored this opinion if he wrote the majority, but maybe he felt her citations were not dispositive to the outcome. And as we already know, he prefers institutional stability over methodological purity. Those are some of the thoughts I had on the 4 recent Supreme Court decisions. Now, let's turn to this upcoming week's 3 Supreme Court cases. And I'm going to give you my final thoughts on these. These are the last 3 cases the Supreme Court will hear for about a month. Check out my case previews in my mega episode for background details. I'm just sticking to my final thoughts for these 3 cases. Okay, let's start with Trump versus Cook. This oral argument pits the Solicitor General against Paul Clement. This will be Paul Clement's 5th oral argument this term and his 2nd in the past 2 weeks. Remember, he argued Chevron v. Plaquemines, which took place last Monday. To prepare for this episode, I checked the docket and reread the parties' briefs. In this case, I consulted the parties' initial briefs and their supplemental briefs. The parties used their supplemental briefs to marshal the amicus brief arguments to show why their side wins. Side note, I think it's an exceptional idea to file supplemental briefs that summarize the amicus briefs. Adam Feldman of Imperial Law wrote some very helpful analysis on the role of amicus briefs in current Supreme Court practice. His January 15th Substack piece called The Rise of Scholars' Amicus Briefs, How Academic Voices Shape Supreme Court Decisions. This piece noted that the Supreme Court cited over 100 amicus briefs between 2015 and 2024. Given the huge role that amicus briefs now play in Supreme Court practice, It's imperative for the parties to be able to respond adequately to the amicus brief's arguments, which can be separate from the arguments that the opposing party makes. The Supreme Court briefing schedule creates timing problems that these supplemental briefs here brilliantly solved. Traditional merits briefs primarily attack the opposing party's legal theories and explain why they should win and the other side should lose. The parties don't spend much time at all engaging with the amicus briefs, which creates a gap in the analysis. Oral arguments don't provide an adequate forum for the parties to systematically respond to these multi-page complex amicus briefs. The supplemental briefs here created that missing link. Stop. Because they allow the parties to engage the amicus briefs directly with the same rigor they apply to the merits briefs. This innovation becomes essential given Adam Feldman's findings on the importance of the amicus briefs. Without written responses, justices must evaluate these amicus brief claims without seeing contrary argument or the perspective of the parties who are the ones with the most to lose or gain from the Supreme Court decision. Check out Adam Feldman's piece for more details. I'll link to the article in the show notes. All right, end side note on the supplemental briefs. Let's nerd out a little bit more. When rereading the briefs, two predominant themes collided across this case and others. First, judicial restraint. Courts must enforce only what Congress actually wrote, what judges think Congress should have written. Under this theme, since the statute at issue in Trump v. Cook doesn't specify a process to give notice and a chance to be heard on allegations of for-cause conduct, the Supreme Court cannot find that Cook had a right to process. It doesn't say if a person gets fired for cause, they can challenge their removal in federal court or whatever forum. Congress didn't write any sort of process. The government argues the court cannot create process where Congress wrote none. Second, a theme that the Cook team pushes, and it's policy-driven, and it's about the paper tiger side of things. If for cause means whatever the president says, the for cause requirements become meaningless. Presidents can gin up anything and fire a person for cause. Or it creates a system that incentivizes prosecutors to bring charges against a person to be fired for cause, allowing removals based on unproven allegations. This creates a perverse system where presidents can target officials for policy disagreements while using fabricated misconduct as cover. These themes will play out in a huge way at oral arguments. Here's a couple of other points. Remember in the Trump tariff cases, a big issue involved whether the phrase regulate importation authorizes the president to impose tariffs. Opponents of the Trump tariffs scored points with the justices on the point that Congress used very different terms when expressly authorizing the president to impose tariffs. These cases connect in a major way to this point. The Supreme Court uses the same arguments. The United States uses the same argument to attack Cook's argument. They argue Congress knows exactly how to give due process. It's written into dozens of other laws. When Congress stays silent, courts cannot create a process out of thin air. That's Congress's job. That's not the role of courts. Now, let's zoom out for a minute and try to harmonize some of the reasoning across cases. If you strike down the Trump tariffs, it seems like you need to also reject Cook's claim about a statutory right to process, right? You can, on the one hand, say Trump tariffs bad, Congress didn't use the right language in the Trump tariffs case, but then say, Cook, you have process. Congress's silence doesn't matter. You have a right to notice an opportunity to be heard. I don't see how those two arguments align with each other. Here's another point. This case must be looked at from the lens of Trump versus Water, the FTC Commissioner firing case. The Solicitor General argued the president can remove an FTC commissioner without cause, even if Congress says the person can be removed only for cause. I predicted Trump will win that case. If the court rules in Trump's favor in Slaughter and in Cook, that likely spells the end of Congress's power to regulate the terms of service of any person in the executive branch. Taking down two longstanding congressional removal statutes in the same term, that would be a huge deal. Speaking of property rights, Wolfer v. Lopez involves a major clash between the Second Amendment and real property rights. This case involved the constitutionality of Hawaii's law. It was passed in 2023, and it prohibits gun holders from carrying their guns onto private property open to the public unless there's signage or express prior permission received from the owner. 4 other states have similar laws: California, Maryland, New York, and New Jersey. This rule is also called the vampire rule because it requires owner consent for entry, just like vampires need permission to enter your home. To understand this case, Wolfer v. Lopez, you need to understand Bruin and Rahimi, 2 recent Supreme Court cases. See the case preview and mega episode for more details. Finally, let's talk about M&K Employee Solutions, the trustees of the IAMS Pension Fund. This case will answer whether pension calculations can use old or new numbers. Remember the restaurant analogy I offered in the mega episode? You eat dinner on December 31st and you ask for your check. The waiter calculates your total using that night's menu prices. Then 3 weeks later, the restaurant says, actually, we're using the higher prices we adopted in January. Your bill is now 3 times higher. That's what happened here. The pension plan changed its math after the fact, tripling what companies owed. This case presents some interesting questions. We'll see how it plays out. Thanks for listening to today's episode. Remember, please follow, rate, subscribe, share, and review the podcast. You can find us anywhere you podcast. You can also follow us on LinkedIn. Reach out to us there or email us at scotus.cases.pod@gmail.com. Talk to you soon.